Alrighty, this is DC We the People News. Okay, not attorney, not giving legal advice. Alright? Never look straight forward, always look around you, be able to protect yourself by any means necessary. Use the Second Amendment, arm yourself with knowledge. Alright? Quit using the person as often as you do and actually start retraining yourself. Call yourself a man or call yourself a woman. Okay? And at the very minimum, one of the people. But quit getting in the habit of the person that the TVs are teaching you to do. Okay? Oh, she's my person. Oh, he's my person. No, that's not what we said back in the old days. Men and women have rights. Okay? People have political power. Persons are just in some form of business contract and they don't have either one. No political rights and no natural rights. They're just bound in a contract of some shape, form, or fashion. Alright. This has come from Sovereign Living. Again, this is a document that is just really interesting and put forth in courts. Okay? And let's go by that and pause that, read it, or whatever. But if you want to check out the original video without my input, I may not do the whole thing anyway, unless you guys actually tell me to finish it up on the deal, because it's a really interesting way of, well, controlling the courts and putting the courts in their place as well, calling them out on their crap in a lot of ways. Okay, let's proceed forward.
Back and forth. Of course, that's Tomlin's Law Dictionary, 1835 edition. So that's getting there pretty old. This is, you can also, there's a lot of different kinds of demurs. You can demur, non-suit is equivalent to a demur to the evidence, in that all of the facts the plaintiff presents are true, the evidence is not, as a matter of law, sufficient to entitle a plaintiff to a judgment. However, a voluntary non-suit, unlike a demur or a directed verdict, which resolves the action on its merits, may result in another trial of the cause. So anyway, so that'll give you an idea about demurs. So we'll go back to the word.
So that way you get the full picture. Okay.
File on demurs. So this was
the you.
Sorry?
I was going to say, if there's a YouTube video, have the word demur in it, but go ahead.
Yeah, there's a...
And I think you guys heard me talk about it before, right? Alleged defendant. Alleged defendant. Alleged.
YouTube video that I did last week about demurs. So you'll find it on my YouTube channel. So this is actually a case from Idaho that I got this demur from, and I sanitized it, took the guy's name out of it, and sanitized the case number and all of that. Comes now, John Smith, a natural person in the above style of action. John Smith denies that this court has jurisdiction over his person. John Smith denies, 1, being a citizen of the United States / citizen of the federal government via the 14th Amendment. Number 2, being an alien from another country. Number 3, being anything other than a citizen of the state in which he is domiciled, which is Idaho. John Smith reserves all rights secured to him by the Idaho Constitution, which include both enumerated and unenumerated rights. John Smith denies that any power exercised by government can arise from any place except from powers delegated to it via a constitution.
Now, I talked about this a while back, y'all. You can go in the courts and eject or anything like that. But I look up the definition of deny. Okay? Which is more beneficial, ejecting? But when you do eject, I will always eject to every single time the attorney opens his mouth. Ejection, Your Honor. Hearsay. Okay? And he'll just basically rule on the attorney's side. And once he starts ejecting, or speaking again, ejection, hearsay. Hey, you're going to keep doing that. I can't. It's hearsay. I can't stop ejecting. Keep speaking. Who's the man or woman making a claim? I'm willing to settle the matter right here, right now, at the here and now. Okay? Who's this Mr. or Mrs. State of Texas? I need them to appear under affidavit of penalty and perjury. Unless that attorney's going to do it. And does he accept the responsibility to be a witness to the Mr. and Mrs. State of Texas claim against I? Remember, I'm not an attorney. I'm not giving legal advice.
John Smith denies that this court can be empowered by the Idaho Constitution or the U.S. Constitution to acquire jurisdiction over the alleged defendant. So notice he's calling himself the alleged defendant.
The deny actually shifts the burden of proof back on them. All right? I deny your claim. Okay? Well, now they have to show the evidence that they are claiming against you. So, Mr. and Mrs. State of Texas, well, I just denied your claim. Now you need to go through the process and actually show me wrongdoing.
And then he throws in a couple cases here. Pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleadings are not to be held to the same high standard of perfection as lawyers. Additionally, pro se...
Now, sit and think about that, y'all. I showed videos, a few videos back, right? The court cases. Well, do you understand? Whatever you do, you're going to be held responsible for the full extent of the law and all that kind of stuff. And all these kind of things, right? Well, see, the attorneys are making plea bargains and saying, well, we'll give you 5 years instead of 10 years. Well, if the judge accepts that, what's the duty of the judge? His duty is to protect and preserve your rights. Okay? The judge is not allowed to actually let you waive your rights. This is attorney nonsense crap. You're not to waive your rights. Judges can't even ask it. But standard practice now, due to our ignorance.
Against are to be given reasonable opportunity to remedy the defects in their pleadings. While the alleged defendant has been accused of being a defendant subject to this court's jurisdiction, this fails to be factual on the basis that the Idaho Constitution or any constitution fails to confer any authority on this court over the alleged defendant, and as such, the alleged defendant denies that he can legally be classified as a defendant until such time as the plaintiff can prove that it has standing. Its representative, the district attorney here in DA, has standing to act as a public prosecutor, and that this court has jurisdiction over the alleged defendant.
Personal jurisdiction, subject matter jurisdiction. This is the reason why you challenge jurisdiction. They say you broke a law, some type of statute, code, rules, and regulations. But where did they derive that authority from? The Constitution. Which part of the Constitution? That's absolute, vague, and ambiguous. Absolutely. And they need to be a little bit more clear how they have jurisdiction. How does the plaintiff have jurisdiction? And if the plaintiff does not provide jurisdiction to the courts, how does the courts have jurisdiction if the plaintiffs don't have jurisdiction? They're the claimant. They're the ones supposed to have standing.
And it goes on. The demur is a formal mode of disputing the sufficiency in law of the pleading of the other side. In effect, it's an allegation that even if the facts as stated in the pleading to which the objections are taken to be true, yet there are legal consequences as such, or are not such as put the demurring party to the necessity of answering them or proceeding further with the cause. See here, an objection made by one party to the opponent's pleading alleging that he ought not to answer it for some defect in the law or in the pleading. A demur cannot lawfully be denied or dismissed. It must be overcome by proof it is false. This is the power of it. I'm telling you, this is pretty slick. Anyways, the Idaho statutes taken as a whole are void for vagueness when it comes to those people like the alleged defendant, who are only...
Now, I love that part, right? It's absolute void. Absolute void. Well, I still go with, you want to make sure that it's strong and they have no wiggle room. That's the reason why I keep on saying absolute, vague, and ambiguous, absolutely, right? Where do they have room to wiggle out of on this statute? Where did it come from? Okay?
Of their states. The Idaho statutes are not the true laws of Idaho as authorized by the Idaho Constitution to be imposed upon those people who are only citizens of their state. The charging instrument is defective, the plaintiff lacks standing, the district attorney lacks standing. The alleged defendant fails to be a person subject to the jurisdiction, to the system of law this court enforces. The court constitutionally barred from acquiring jurisdiction over the alleged defendant and overriding relevant fact.
And I would even go a little bit further, barred from there, and then put and committing domestic abuse on the people. Right? Because in common law, domestic abuse wasn't family. Domestic abuse is actually government against the people. That's what domestic abuse came out, the original intent on that. And then some ladies in the family courts went to the Supreme Courts about this. And, well, they found that the domestic abuse on the women was unconstitutional. They didn't clarify why it was unconstitutional, but they did clarify it was unconstitutional. Well, that's because domestic abuse came from the government down to the people. And the reason why the Supreme Court didn't clarify it is because they didn't want the people to know that you can charge our government officials domestic abuse. You can't make this up, people.
Due to the above being true, this court cannot acquire jurisdiction over the alleged defendant and is therefore duty bound by the Idaho and United States Constitutions to dismiss this case and order the alleged defendant released. John Smith alleges that any other action will constitute a violation of the rules of due process applicable to the alleged defendant and it will constitute a violation of your oath. Therefore, if the court has jurisdiction over the parties and subject matter, its actions are not void, no matter how erroneous they may be. On the other hand, judicial action without jurisdiction is void. Where the court is without jurisdiction, it has no authority to do anything other than dismiss the case. Judicial action without jurisdiction is void. And that's a couple of court cases that support it.
All right, if you want to read that, I'm going to go ahead and end it with this right here. I'm probably going to go ahead and go with one more without my interruptions next time, okay, people? Go back and listen to it one more time and see how strong this actually is, and realize, you know, people are waking up every day realizing how the judicial branch don't even follow their own rules, let alone the Constitution. And the statutes are absolute vague and ambiguous, absolutely, to have wiggle room for, with officers to even arrest you and say, "Oh, gee, I thought I did everything correct." Reasonable doubt and all that kind of stuff, and they get their little immunity. This is We the People News. Bye, y'all.